I'm Andrew Katz. I'm a technology lawyer who has been specialising in open technologies, including open source software and open hardware for over 25 years. I've always been fascinated by computing and technology, and I worked as a software developer for a while ago, before becoming a lawyer many years ago. So, what's the fascination with openness? Well, as a lawyer, I work with rules. And we tend to end up with an edifice of ever more complicated rules, as an initial set of rules leads to exceptions, and exceptions lead to more exceptions, and so on. So it becomes complicated. It's messy, and it's inelegant. Software developers talk a lot about elegance in code, and it's difficult to define, but we know what it is when we see it. It embraces concepts like concision and clarity, which are often quite difficult to achieve at the same time. Robustness and inventiveness, like the creation of a new algorithm, just a way of saying, a way of doing something in a computer, or possibly a novel application of a particular algorithm to a problem that you normally wouldn't see it applied to. In science and mathematics, sometimes something very simple can lead to remarkable complexity. So Newton's simple equations of motion can predict the positions of planets to a remarkable degree of accuracy. And Darwin's theory of evolution, by means of natural selection, can, through a very simple premise that entities capable of imperfectly replicating in a resource-constrained environment will lead to those entities which are more suited to their environment being likely to survive. It's possibly the most elegant theory ever created, a set of starting conditions, entities that can replicate in circumstances constrained by the amount of certain raw materials, unrestricted energy, means that over an extremely long time, all of life has arisen in its multitude of types and species, many living and many extinct. And this property, where complexity arises from simplicity, is called emergence. The elegance arises from the fact that something highly complex can arise from an incredibly simple set of starting conditions, coupled with simple rules describing what happens over time. You can get to a complex position in something in two ways. You can either describe the complex position in a lengthy, involved, and itself highly complex way, or you can start with a simple premise and apply some simple rules. And the latter approach is what we would call the most elegant one. So I personally am not blessed with a great memory, and my approach to learning about anything in any field has always been to try and discern a pattern, generalize it, and then extract a set of rules which can apply to a different set of facts in the same field. So it's an approach which works well for mathematics and science, but somewhat inconsistently when it comes to the law. So some subjects, like the law of trusts, are very amenable to this idea. And in many ways I would describe the law of trusts as being quite elegant. Others, like tax law, are more about just simply learning a set of statutes. So one aspect of elegance is finding that a solution to a problem has already been found in relation to another problem, which superficially appears different. And this is something that happens occasionally in mathematics. And if the problems can be mapped onto each other, so an identical solution can be used, then the problem is called isomorphic. But even if the problems aren't identical, you can often take a known solution to an existing problem and tweak it slightly to deal with another similar problem. And lawyers do this from time to time with what's known as a legal fiction. So copyright is something that automatically arises when you create something like some text, an image, a film, some music, or a computer program. And broadly, this right means that the creator can prevent other people from copying the work they've created, but they can grant them licenses to use it, and those licenses can have conditions, such as a condition requiring payment. But what happens if the creator wants to sell the whole of their copyright to someone else, or they want to leave it to someone in their will? So trying to address all of these eventualities in the legislation can make copyright legislation extremely complicated. And it's not really exactly simple as it stands. So the solution used by the legislators is very simple. Property, so-called, like a car or a piece of land, is something that you can sell or you can leave to someone in your will. So if you legislate that copyright is a property right, then you automatically apply all the other rules that apply to property, like how to deal with it in a will or sell it to someone else, just tweaking the bits that don't work for this particular use case. And Section 1, Subsection 1 of the UK Copyright Design and Patents Act starts with the words, copyright is a property right. And it works very well by and large, but it inadvertently creates a problem. Some people believe that copyright is like a property right, in that you can do a lot of things with it that you can do with property, so unless those things are modified by statute. So, for example, property lasts forever in effect, but copyright only lasts for a limited period, in many cases for 70 years after the author's death. Other people believe that copyright is a property right, and that all the moral baggage that attaches to property also applies to copyright. So in other words, rather than copyright existing as a mechanism to allow creators certain limited rights, which will act as an incentive for them to create more, there is a basic moral imperative that people should own what they create, and that it's immoral to try to limit that. And this is a topic which is much more settled in the American legal tradition, as the purpose of copyright to act as an incentive is explicitly set out in the US Constitution. So this means you've got two schools of thought. The creators have a natural right to their copyrights, and therefore any derogation from or relaxation of those rights should be subject to stringent scrutiny and justification. And the other school, which believes that copyright should be as relaxed as possible and should only extend as far as is necessary to provide an incentive for creators to create. But the problem with that is how do you go about measuring this? And one approach might be to roll back copyright constraints very significantly and see what happens. And open source software and the other opens could be seen as a great experiment in doing this, reducing constraints and seeing what happens. So open source software is software, the source code or recipe to which is made available on terms that it can be studied, used, modified and redistributed freely to others with or without some simple conditions. Such as you have to retain copyright notices and attributions, and in some case you have to make sure that if you modify the software and share it with others, then it has to be subject to the same sort of condition requiring its recipient to share alike, and if they distribute to others, and so on and so forth. So the terms on which the software is made available and on which it can be used, studied, modified and redistributed are called the license. Although there's a fair number of different open source software licenses, they all have these characteristics in common. They all allow the software to be studied, used, modified, and redistributed freely to others with only minor conditions. It's a simple set of conditions, and like the theory of evolution, it's premised on a very simple rule, which also happens to apply, as it happens, to replicating entities. So free and open source software is a concept that has been emerging and developing for well over 30 years. And this very simple set of rules has developed some remarkable emergent complexities. This not only relates to the software itself, but also to the structures that have arisen in the development and governance of software products. It's been observed that the license itself can fulfill many roles. So the obvious one is the granting of permissions covering use, distribution, etc. But it can also act as a manifesto for the movement around the software or the organisation creating it. So, for example, the Free Software Foundation takes the view that software is essentially knowledge, and as such it's morally wrong that it should be kept private. There should be no restrictions on its reuse. The family of open source licenses it has developed reflects this stance by requiring that software which is an adaptation of or combines with free and open source software in certain ways itself has to be open source software. That way the pool or commons of free and open source software is forever expanding. There's no doubt that free and open source software is immensely successful. There are any number of statistics showing that open source development is ubiquitous. Every mobile phone and every supercomputer relies on open source software. It's a huge financial driver. So IBM's acquisition of Red Hat, which is a company which supplies products and services based solely on open source software, was at $34 billion, one of the biggest tech acquisitions in history. And it's immensely innovative. The World Wide Web is built on free and open source software. So it's rarely that we have an opportunity to see how a very simple set of rules, often counterintuitive, can be so disruptive and unleash such a great and sustainable wave of innovation, community, and economic activity. It's undoubtedly worked for open source software, and it will be fascinating to see whether other fields, like open hardware and open data, can benefit from the same dynamics. How can you not be fascinated by that? That's it.
Awesome.